Now, the other elephant in the room is Proposition 8 and the decision that came down yesterday with standing for the supporters of the measure with their standing in court. And you authored that opinion. So, discuss.
Where do I begin? Well, it was a unanimous opinion, and really, as the opinion states, that this is about Prop 8, but it was really about the initiative process. It is about direct democracy. I mean, you can find legion historical pieces on the advent of the initiative. You know that we just recently celebrated its 100-year anniversary. It wasn't always in the California Constitution. People will quibble with how an initiative qualifies. I get that. But we work with what we have. And what we have is the initiative process still is the voice of the people. It is used to bring about and effectuate change when the legislature cannot. The more polarized a legislature becomes on a particular issue, the more you're going to see that issue in the initiative process, by groups that decide to bring that through direct democracy to the people. So what Prop 8 is about, I can't speak to what Prop 8 is about. What I can tell you is that in California, we unanimously decided that the initiative process is protected, that it is the voice of the people, and when it's passed, when the initiative has sought and achieved voter approval, that is, the people of this state have voted for that law, whatever it might be, the process itself deserves protection. And when the government officials who would normally defend that initiative in the courts decline to do so, and only under those kinds of very narrow circumstances do we afford official proponents the authority to assert the state's interest. And that state interest is what the people approved. And so, for me, it is a part and parcel of the initiative process and direct democracy.
So I'm going to finish up my questions with sort of a tie into that. When I went on YouTube, and your initial speech when you accepted the nomination, you talked about your commitment to the public trust. And this seems part of what you're thinking about the initiative process. I was hoping you could just address your commitment to what that means to you, the commitment to honoring the public trust that the court has.
I think I've thought about this in the sense that I started off in Muni Court, I went to Superior Court, I went to the Court of Appeal, and now I'm at the Supreme Court. I've gone from the beginning, and surprisingly, to the top. And the reason the Chief Justice chairs the Judicial Council, in my view, the reason the Chief Justice is the head of the policy-making body for the statewide branch, is because by the time you become chief, you have no further ambition or aspiration. You are really, at this point, having experienced every level of branch, every level, having seen issues and attorneys, and really fundamentally understanding and respecting how the process works. What happens to me, anyway, is I've come full circle. I serve the public. I started off serving the public in the district attorney's office. As chief now, I serve the public. So all of my decisions are guided by what's right for the public, what's right for people, like my mother, who doesn't know what I do, doesn't know what the court does, but knows when she feels wrong, she has certain rights. And so it's like Judicial Council. I've come to view, and I believe this firmly, that the Judicial Council, which consists of 31 people who are not, they are not a representative body. We're not like the legislature. We don't pick people from Sausalito and people from Yuba City and people from Sacramento and people from LA who come in with a constituency and vote what's right for their constituency. The Judicial Council exists to serve the public and the courts. That's who it served. I mean, if you looked at the basis for why the Judicial Council exists, the ballot argument in favor of the Judicial Council in 1926 said, when there's a problem in the courts, it's nobody's problem. So we're going to create a Judicial Council. So when there's a problem in the courts with the parties, the public, they have some place to go. It becomes the problem of the Judicial Council. Well, I read that as meaning the Judicial Council serves the public. The trial courts as well, the Court of Appeal as well, the attorneys as well. But every one of those three groups has representation, and they know how to be represented, and they know how to effectuate change. It's the public that doesn't. So Judicial Council exists ultimately for the public. That's why its 31 members are not representative. It's a statewide perspective. The chief has a statewide perspective for the reasons I've described, and because by the time I think you become chief, you really do embrace the kind of public service that judges undertake. And so it is a public trust. It's also, I tell you, I'm reminded of the public trust every day I go to the Supreme Court. I walk down the halls and I see pictures of these very old men with very long white beards. And they're wearing very skinny ties and three-piece suits. And I know one of these days I'll be on that wall. Because it is an institution. Because it is not about me and my interests. It is about the public and the institution. That's where my feeling about public trust comes from.
Now, I'd like to open this up to the audience. I'm sure there's lots of questions, follow-up questions that people have. I see in the back.
What can we as lawyers do to help the judicial branch and the CCMS program?
Thank you. So the question is, what is we as lawyers can do to help CCMS and the judicial branch? CCMS, if you're not already aware, is a computer system software owned by the courts. Owned by the judicial branch, created by judges and lawyers and court executive officers and staff, that is basically what I call courts online. It is an opportunity for you, for example, if it's up and running in all the counties, you can be in Rio de Janeiro on vacation. You can seek to ruin your vacation. You can go online. You can look up the opposition to your motion for summary adjudication. And you can pull up the document online from Rio de Janeiro for the opponent. You can also decide that the defendant you're suing, you wonder if he's a defendant in Kings County or Del Norte. And you would be able to input that information and find out where that party is a defendant elsewhere in the courts. If you're a criminal practitioner, if you need to find out whether your client has been convicted of other matters in another county or has 18 restraining orders against him or her, you can put that in and you can find it. So in many ways, it's a clearinghouse of information for access. The public has a certain amount of access. Lawyers have greater access. Those who represent people on certain cases have absolute access. Judges have everyone's access. So it is truly an amazing component, helpful, needed, useful tool for the judicial branch and for practitioners. It will change how you do business. Orange County, I know, has gone completely online with their civil litigation program. They destroyed all paper, and their complex litigation program loves this. And they want it so much that they're willing to spend their own money and bring in more component parts of CCMS. CCMS handles all 17 case types: family law, probate, criminal law, civil, everything. The trouble is, we don't have the money to deploy it. We don't have the money to put it into the courts. The courts have multiple case management systems, computer systems in every county. So when I was in Sacramento County and I was a trial court judge, if I was sentencing someone, I wanted to take care of his family law, take care of any juvenile matters, take care of his traffic, take care of anything out there. But I couldn't, because my criminal calendar computer couldn't speak to traffic, and it couldn't speak to juvenile, and it couldn't speak to civil. So I had to call up, continue the thing 4 times, bring the guy over, try to get hard files, and try to clean everything up before I sent him to prison for 3 years. It didn't work. It hasn't gotten any better. So CCMS is a tool. What can attorneys do? Attorneys can start talking about the need for it. Attorneys can speak to its defense. There are people who would rather us take any money we have for CCMS and give it directly to the courts. But CCMS will change business. It will make us more efficient. The courts do need money. I'm not going to argue with that. But I will tell you that the courts need money, but not by cannibalizing other projects in the courts. We're only 2.4% of the pie. We can't, it's not enough. And so if you kill CCMS or you kill construction, it's not enough. And what do we do next year? So the point is lawyers need to talk about how much they need it. They need to call legislators to support it. They need to, when they read articles about wanting to kill it, they should feel that they should be indignant, because this is something the branch, lawyers, the public, the press needs. So I ask you to, if you hear about it, if you hear it's in jeopardy, if you could send a letter of support, that would be helpful, because all I do is fight the CCMS battle there. Because it's an easy thing to say, don't do it. But if we don't do it now, when will we ever do it? We will never be statewide communication accessible if we don't start making and coaxing us into the 21st century now.
It's really exciting to hear. It's constantly something that our bar association gets asked about online and e-filing. It is probably the #1 issue that every year, when is that going to happen? How is that going to happen? And I know it's a really complicated issue.
Well, we have it. We own it. It's over. We know it works. We've had independent evaluations of it. So now the question is cost benefit.
All right, well, let's get it going, because I know it's something that's really coming up here. More questions for Stan?
In these budgetary times, some people question the budget to the AOC, and I know that's a complex issue. What can you speak to that?
Thank you. That's a good question. The AOC is the administrative office of the courts. And what it is the staff arm to the Judicial Council. And it also exists to do for trial courts what they cannot do for themselves. So, for example, on the Judicial Council, all of us have daytime jobs. So we cannot do the legwork and the research necessary for some of the initiatives and proposals that come through the Judicial Council, or the necessary rule changes. They're done by the administrative office staff, and then they show it to council and recommend that we adopt certain changes or certain rules. When I came on to being chief in January, I'd heard over the years concerns and questions about the AOC budget. But again, this goes back to my, people tell me something, I know what their opinion is, but I don't know the facts. So what I did is immediately upon hearing this and surveying judges, I put together the Strategic Evaluation Commission. I call it the SEC. And it consists of judges and justices, current and retired from around the state, in addition to some state administrators in the executive level. And what they're doing is they're assessing the AOC. They're evaluating whether or not it continues to meet the needs of the Judicial Council and the trial courts that cannot do for themselves what, for example, a larger court could do. For example, Trinity County, maybe 2 judges. They don't have a payroll person. The county used to do that for them. But when we took over state funding, the county dropped out of doing responsibilities for the state courts. So now the AOC does that for them because they don't have a payroll. We're not going to pay someone to come in to do that for them. We have a system. So the AOC provides services to the courts. What I need to know as the new chief is, what is our budget? Are we spending it correctly? Do we have priority of services? And so that study is being conducted now by these judges. They're doing surveys of all the judges, all the counties, finding out how much do you use the AOC? In what ways do you use them? Should we drop off some of these services so we can save money? In fiscal year 11-12, several things happened to the AOC though. 12% of their budget was cut as part of the cuts across the branch. The trial courts took a 6% cut. The appellate courts took a 9% cut. And the AOC took a 12% cut. We also had our administrative director retire. So we are headhunting for, in a national search, a new administrative director. So we have changes afoot in the AOC. But for me, those changes have to be based on facts and not about opinions about someone may have. And I've worked with Judicial Council for a number of years. I couldn't tell you, in all honesty, whether they were too fat or too skinny. I couldn't tell you. So I'm hoping that this survey will better inform my decision about how we move forward with an AOC and a new administrative director who will get a lot of new information about restructuring the AOC to better fit the needs of the Judicial Council and the trial courts.